And tonight, Chief Justice Gertrude Torkornoo is gone. She is no longer the Chief Justice of this great republic. That decision was announced to this great republic by the presidency today. This is unprecedented. It's the big news. This has been unfolding in the last few hours on the back of the presentation of a report by the committee that the president constituted pursuant to the constitutional provision. And she's gone. She was found guilty on stated misbehavior. That was established today and presented to the president. In fact, was established by the committee but presented to the president today. And the decision that the president have to abide by. The president has no choice in the matter, we are told. And once that establishment had been made and a case made on this subject of misbehavior, the president had to simply comply. This, in essence, is at the heart of the decision to remove Gertrude Torkornoo. That is the decision tonight, as communicated by the presidency on this major subject. She's been on the bench for 21 years. So this is a long-serving justice of our courts, and she has really served long and hard and put in the hard yards to reach the Supreme Court. She served on the bench and rose to become the Chief Justice. This is the first time we're seeing this play out for somebody with that background and service to the judiciary, and also, as you know, in the judiciary, seniority is very important. It doesn't mean that on the bench they're wearing other justices of the Supreme Court who have not served longer on the bench than her, but of course she became the Chief Justice, and we don't know that she's no longer going to hold that position. She's been on suspension for a while. That is no longer the case. As we speak tonight, you can now call her former Chief Justice after 21 years on the bench. This case has traveled a fair bit. And let's get into the background. If you recall, the petitions were first submitted to the president as dictated by the Constitution. And then the Council of State was giving the mandate to evaluate it and determine whether there's a prima facie case. And remember that the Council has former Chief Justices on it. And part of the reason why they're on it is because of the anticipation that this may become a live matter, and the Constitution had anticipated it. And that is why we saw that they sat on the matter and they came to a decision that is a prima facie case against the then Chief Justice, who is no longer the Chief Justice because she's been sacked today on the back of the recommendation. Following that, we know that the 5-member committee was formed against pursuant to the constitutional provision. The president must set up that the committee to look into the matter on the back of the Council of State findings. And then the Chief Justice herself, in May, on the back of the committee being formed, because once the decision had been made that it's a prima facie case against you, there's a case to answer, she had to be suspended. The president did so, suspended her. She fought it in various forums, not only her, but others also, mainly political elements in the MPP who went to court and fought this pretty hard. In all the cases that were filed in court, they were thrown out. She lost in different forums that she took this up in. The committee then submits its recommendation, which also happened today. Shortly thereafter, we were told by the presidency that they have accepted the recommendation of the committee, and that the president had a choice in the matter. And it is obvious now that the committee, that by the way had two colleagues of Justice Torkornoo, also sitting, one of them was a chairman, Scott Palman, two of her own colleagues came to the conclusion that she had misbehaved. There was enough grounds to establish a case of misbehavior against her that justifies and warrants her removal, which is exactly what the president had done today. It has been 133 days since, as you know, the first petitions went to the presidency. It's traveled quite a bit. I mean, and this was in April 2022, if you recall. And it has been full of drama. Remember, for the first time we saw a Chief Justice, although at the time suspended, address a news conference. Never seen that before, about what at the time she complained of violations of her rights rights a fair trial, a fair hearing, and that she's not been treated as she would have as the Chief Justice done to those coming before her. And she raised several allegations against the committee. Today, the committee actually said a lot of the allegations that were made against them were false, but they restrained themselves. So these 133 days has been full of drama, and topped it all with the removal today. As I'm talking, you may be wondering who really are the members of this committee. And the sense is clear. This was a committee recommendation. It was unanimous. All 5 members of the committee agreed that the Chief Justice needed to go. Chairman obviously communicated this to the President. He presented it and spoke about their decision without telling us exactly what the conclusions were. Justice Scott Parman, who chairs it, is a colleague of the Chief Justice. Justice Adibu Asidu, colleague of the Chief Justice too. And I must stop here to give you a bit more of the drama that unfolded on the back of this. He was one of those accused of allegedly meeting to conspire to remove the Chief Justice at a restaurant here in the Greater Accra region. And we showed you the evidence because the CCTV footage emerged of that. It was really a dinner because it was his birthday and he had gone there to celebrate and to simply have dinner. And an allegation was made and a petition was sent to the presidency. The claim was that they had met and they had been overheard plotting to remove the Chief Justice and trying to sort of agree on how best to proceed with their removal. The evidence showed that that isn't the case. And because the CCTV was approved, and this meeting was a fairly brief one, they had met, and that really wasn't a meeting where we also saw the lawyer, one of the petitioners, also having a meeting at the same venue. And the accusation then was that they had met this lawyer and they had discussed and plotted because the petitioner's lawyer was there and was conspiring with the judges. We saw that the footage didn't show that at all. So that really is part of the drama, one of the major dramas that unfolded on the back of this. When do you see CCTV footage emerging of judges going to a restaurant to have dinner and being caught on tape, and allegations are swirling around what the intentions were for going there? But all played out in 133 days that this was before the committee's hearing. And then you know him, Daniel Doolowo, famous for the role he played as a former Auditor General, no-nonsense man who really himself was the subject of a very controversial removal by the then President of the Republic, Nana Addo Dankwa Akufo-Addo, was forced to retire, and he then got to sit on this matter too. And then we also had Major Flora Dalugo of the Armed Forces, and then we had Professor James Jisa, Associate Professor at the University of Ghana. By the way, the composition of this committee is specified in law, it's in the Constitution. The President had to comply. The individuals, as in the specifics of who they were, is not specified. However, their qualifications and who they should be, the criteria is very clear, and the President had to select the individuals. And clearly, from what we understand, this was a unanimous recommendation by all 5 members of this particular committee. And this is another part of this process that was fascinating. When the process started, the Chief Justice herself, although the matter was in camera, took the case beyond the committee, and she went and she fought pretty hard, tooth and nail, both at in the courts here in Ghana, the same courts that she superintended over as the Chief Justice, and lost all the cases. She wasn't the only person who did so. There were others in Parliament who also took up cases in the courts, fighting the process to remove her. All of them failed. At least 6 suits were filed. As we speak, she's at the ECOWAS court, so trying to deal with this matter. We'll try and unpack that part of this, though, because while that case is ongoing at the ECOWAS court, the decision has been taken that she should be removed, and she's no longer the Chief Justice. So really, what's the remedy there? We'll talk to the lead counsel for the Chief Justice, who's joining me tonight for a conversation. We know that it is Daniel Ofori's petition, the three of them. Daniel Ofori's petition is the one that the committee has decided on, because they finished that. Daniel Ofori brought 13 witnesses. The Chief Justice had 12. She was cross-examined. They evaluated it, made a recommendation to the President. The key question then to ask is, what happened to the two? They're still pending. So how come they've come to a conclusion when they haven't had the other three, the other two, by the way? It's a fundamental question. And can you do that? Will this so proceed? So will this go on? Or is it the case that once you found her culpable on the first one, there was no need to proceed with the other two, even if on the other two very separate and distinct petitions against her, it didn't matter in any case? So that, for me, is a fundamental question that we need to ask, because the committee itself, when they went to the President, were clear that the Chief Justice had asked that in the two cases should be deferred. And so we'll get into that pretty shortly. Now, if you look at the first case, the case of the Daniel Ofori, he made 21 allegations of misbehavior against the former Chief Justice and 4 allegations of incompetence. This is far more difficult to prove than this, and they found her to have misbehaved. There was grounds for misbehavior, which is why fundamentally she's gone. What were the allegations? Just to refresh your memory, the primary one around which a lot of the controversy revolved was this allegation that she misappropriated 337,000 CDs on foreign travels, not only for herself, but for the husband, for the spouse, and others that she wasn't entitled to suspend. There was also cases against her of unreasonably fast-tracking Afenyo marking versus the speaker hearing, arbitrarily reassigning cases between judges, dismissed judicial staff over minor offenses, ordered national security to seize High Court computers, all cases made against her by Daniel Ofori in his petition. But if you look at it, though, details of the committee's hearing on the Daniel Ofori matter, as we have now come to learn from the committee's report, that the Chief Justice personally testified when the allegations were made against her. And the CJ, we know now, called 12 witnesses to testify on her behalf. We've read that some of these individuals who testified on her behalf include a former Chief Justice, for example, that came before the committee. How come their testimony didn't hold sway, convincing the committee to let her pass? We'll talk about that. Ofori also presented 13 witnesses. But this is fascinating indeed. 10,000 plus documents were all filed in this particular matter. That's quite a bit of documents filed. And the second and third petitions to be heard later. We'll talk about that. Is there even a case for it to go on? The main question now we need to ask ourselves is, what happens now? This is fait accompli, is it not? Is there any way back for her? The Constitution doesn't provide a path for her to challenge or mount an appeal process. It's not part of this equation. And so this is fait accompli, it's done. The big question is, who becomes the next CJ? 3 names pop up. You obviously have the man who is acting, but for money. You have Justice Scott Parman, who obviously is the chair of this committee, very senior indeed. When he isn't there, he is the most senior. And many who also settle, many people's favorite, Justice Yoni Kulendi. In fact, at the time when Justice Tokono was being considered, many thought it was a straight race between herself and Justice Yoni Kulendi. Many say, because of his background, because of the work that he's done in the private sector, coming in now onto the bench, and the many fantastic judgments that he's written since getting onto the bench of the Supreme Court. He's young too. He's pretty progressive in his thinking. He seemed to be the man if you really want change in the way the judiciary operates. You want to consider Justice Yoni Kulendi. So that fundamentally is looking ahead to who succeeds Justice Gettu Tokono. 2 of them belonging to the old guard if you want freshen things up a bit and give a new lease of life to the judiciary, many will say, well, Jody Kulendi should be the one to consider. My guest will join me for a conversation on this big day in our democratic history. What does this mean for our democracy? My guest will Wayne. Stay with me here on PM Express. And thanks for staying with us here on PM Express, and a big conversation indeed in prospect. I'm looking forward to talking to those who understand this process better than most, including the lead counsel for the Chief Justice, the former Chief Justice now, Justice Gertrude Tokon, who will also join us on Zoom. In fact, he's on as we speak. He is a renowned lawyer, a very old lawyer. He understands the game fully, and I'm delighted to have him. He's a former Attorney General too. He was in court. He was before the committee representing the Chief Justice, and here Ikotu will join us. But as you know, PMS is always brought to you by Syntex Tanks. It's also brought to you by Academic Times and Pepsodent Cavity Fighter Toothpaste. If you're talking about water tanks, then you must find out the secret. The secret is simple. It is the tank with the tortoise on it. If you don't have it on the tank you have, that is the sign of the tortoise, then it's not the correct tank. The tortoise tank, the Syntex tank, is the champion of water tanks. It is strong, it is durable, and built to handle our Ghanaian weather, rain or shine. Syntex tank has your back. Syntex tank, are you strong, are you tough? And then there's the Academic Times Journal, which is launching pretty soon, a distinctive graphic publication, and a journal to showcase and empower students across all educational levels. With the journal and the tertiary G seeks to ensure that tertiary students' research makes an impact by contributing to institutional and national development. So watch out for that. But tonight, before you sleep, please brush your teeth. It's very important. The dentist advised that, but also look for Pepsodent Cavity Fighter because it prevents decay, gum disease, and the foul breath that you may have. Brushing your teeth every morning and night with Pepsodent Cavity Fighter gives your teeth the protection they need, leaving you with a 10% stronger teeth. Pepsodent, every smile matters. My guest joining me for a conversation is Kwaku Ansah-Asare. He's a former director of the Ghana School of Law. He has his own institution that trains lawyers as far as the LLB, LLM too, right? Yes, grateful. That is Mount Crest, and he joins me in the studio. Inusa Fuseni is a former member of Parliament. He's a lawyer himself. He used to be the ranking on the Constitutional Legal Affairs Committee in Parliament. He's no longer in Parliament, but he's a former MP for Tamale Central. Delighted that he can join us on the matter. And then Nia Ikotu is a former Attorney General and lead counsel for the Chief Justice, former Chief Justice, I must add. We're all getting used to that. She's not a former Chief Justice. And Professor Kojo Apejetia is a professor of international law at the University of Ghana. And gentlemen, thank you very much for your time. I want to start with some fresh details that we are now getting on the subject of the removal. As you know, and as I explained at the beginning of the show, the president was acting pursuant to the recommendations made by the committee that was set up on the back of the constitutional dictates. That committee made a recommendation. What we are now learning is the reasoned position of the committee members that led to their conclusion that the Chief Justice must go. I'm going to read that as to start with. And I want to ask Ikotu. Ms. Ikotu, have you received this formal communication, giving you a bit more detail on the reasons behind the decision to recommend the removal of your client? Please unmute for me. Do we have Ikotu on? Okay, please unmute for me.
Hello.
Yes, great. I can hear you now. I'm just wondering if you have received the full reason behind the committee's work.
I have.
Okay, good. Because you have, for the benefit of my audience, I want to read that. It's just 2-page, and so it's simple. I can go straight to it. The first part just gives us background which we all know. But I want to go to the meaty part. It says, after full inquiry, the committee has submitted its report to the president recommending your removal from office based on the following findings. And this is important. Quote, in the opinion of the committee, the travel expenses which the Chief Justice heaped on the judicial service when she traveled on holidays in September 2022, first to Tanzania with her husband, and second to the United States of America with a daughter, together with the payment of per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. It cannot be justified in law or policy. Those acts constitute avoidable and reckless dissipation of public funds, and in the view of the committee, to have been occasioned by the overall head of the judiciary and the judicial service, whose duty it is to guard public resources allocated by government, is caught within the spectrum of stated misbehavior. So that's the first one. Second, the committee states without fear or favor that the Chief Justice unjustifiably breached the provisions in Article 296A and B of the Constitution, 1992, in the way and manner that she transferred Mr. Bading. Her conduct amounted to misbehavior. And then there is a second part of this that also tells us a bit more about another ground for their recommendation for her to be removed. That the committee is of the view that the conduct of the respondent is squarely in the category of conduct described as stated misbehavior under Article 1461 of the Constitution. The committee is of the opinion that the action and conduct of the Chief Justice falls within the meaning and categories of stated misbehavior as provided under Article 1461. Quote, however, the Chief Justice cannot lay claim to ignorance of the nomination process and procedure, notwithstanding the fact that the process and procedure are not spelled out in the Constitution by case law. The appointment of the Chief Justice herself as a Justice of the Supreme Court went through the very process and procedure set out in the Ghana Bar Association case. Therefore, to seek wittingly to outwit this known process and procedure for appointing Supreme Court justices amounts to misbehavior in the eyes of the committee, and the committee finds it as such. And just a little bit of context. This part is in reference to the contents of the petition that alleged that she circumvented the constitutional process in recommending to the president at the time, Nana Akufo-Addo, the appointment of some justices to the Supreme Court. And that, by the way, was a subject of, broad public criticism, including the first time we saw the GBA publicly on the show criticizing the Chief Justice for circumventing the process that has been practiced and implemented for so long. And so that is the context of this last ground, that she circumvented that process, and that was stated ground of misbehavior. The committee recommended your removal in the following terms in view of the findings of the committee in the paragraph stated above of the Constitution. The Chief Justice, Erabas Isabatokono, ought to be removed from office. So that basically are a few of the details that we're learning that led to the recommendation for her to be removed. And then we've seen John Mahama's own signed letter on the back of this. And I want to read that quickly. And he says, now, therefore, know ye all men that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of said Article 1469, do hereby remove the said Chief Justice, Justice Gertrude Sabais Tokono, from the office of the Chief Justice and Justice of the Supreme Court with effect from the date hereof. And this date is today. Let me start with you, Aiko. Now that you've seen the real reasons, you concede that there is enough basis to remove her, your client?
Thank you for having me. I must say that when I was asked to come on this program, my understanding was that we're going to have an extended discussion, having spoken briefly on the 5:30 top stories program. But now it turns into a panel discussion. Well, as I said, we have been served with it, and I was going to talk about it. You would see that some of these matters were leaked into the press very early, and yet the figures were just being bandied about. I've therefore decided to read what we received in respect to these allegations, especially those having to do with the money. In 2023, the Honorable Chief Justice misappropriated the sum of 261,890 cedis of public funds for the benefit of the Chief Justice for a private foreign travel with her husband, Mr. Francis Kofi Tokonu, and a daughter, Miss Edem S.A. Tokonu, and $30,000 in per diem allowance went to her knowledge. Neither the husband of the Chief Justice nor the Chief Justice's daughter were entitled to have their travel or any travel allowances paid for out of the funds of the Judicial Service. Now, the second one is in 2023, the Honorable Chief Justice misappropriated a sum of 75,580 cedis out of public funds for Ethiopian airline tickets for the Honorable Chief Justice and her husband during the vacation of her ladyship to Arusha, Tanzania. In 2003, leadership, the Honorable Chief Justice obtained from the Judicial Service unaccountable interest, the sum of $14,000 to the Honorable Chief Justice to travel with her husband to Arusha, Tanzania, which she failed to retire. These were some of the issues put forward in the press. Now, committee tells us that they found stated misbehavior with regard to these matters. First of all, Article 1461 of the Constitution, which talks about grounds for the removal of a justice of the Supreme Court or Superior Court, states as follows. A justice of a Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on ground of instability, inability to perform the functions of his office arising from infirmity of body or mind. Nowhere do we have a definition of what stated misbehavior is. And now you see in this letter saying that it falls within a spectrum of something called stated misbehavior.
It says unlawful expenditure of public funds. Unlawful expenditure of public funds.
Yes, but there is no such definition. That's all right. You let's now go on. When you charge a person, the person has every right to explain to you the circumstances under which certain activities happened. We tendered a letter of appointment, which allows 2 travels in a year for vacation. We also tendered what they call the travel policy of the Judicial Council. Now, I have been there before as a minister and also High Commissioner. When these entitlements come, it is not for you to determine anything. You are just to determine whether you want to travel. So when you tell them that I intend to take my vacation in Arusha, Tanzania, then the officers will work whatever is your entitlement and bring it to you. These are not new. This is nothing new. As Attorney General, as an ambassador, that is what they do. They work out and bring it to you. You are not involved. So it is for them to look at the policy. What is the policy? Are you entitled to per diem? They will tell you, yes, you're entitled to per diem. If you are traveling with somebody, is that person also entitled to some per diem? They say yes. And so they work it and bring it to you. What wrong did the Chief Justice commit for asking to go on the usual vacation as part of conditions of service and saying that, well, I intend to go to Arusha. And then the judicial secretary, the head of finance, travels, all those who have anything to do with travel, work on it and give the Chief Justice what is an entitlement. And again, as I said, there is a foreign policy or travel policy for the judiciary. They never refer to it. And that travel policy
You mean
says,
the committee didn't refer to it?
They didn't refer to it, although we tendered it. That, look, this is the travel policy. She's entitled to travel with one person of her own choice. And she chose to do this. Remember that there have been other Chief Justices, some of them who had no spouses. And therefore, the law as at the time was that you could go with, if it's not your spouse, any person of your own choice. And so what wrong did the Chief Justice commit? Was she the one who asked that she should be given travel expenses? Is she not entitled to the travel expenses? And as I keep asking, when you are in that office and you have to travel, is it for you to determine I want this or that? It is for the organization to work it and give it to you. Assuming it was wrongly given to you, is that not why you have audits? Is it not the case for auditors to say that we think that you should be surcharged with a certain amount which you took unlawfully? Is it a grant for removal? Are you the one who are you the spending officer when the letters were actually, even management letters and whatever, were sent to the judicial secretary, who is a spending officer, and no wrongdoing, no surcharge? And I'm surprised Domelevo was on it. He sat through it, he heard us. We made presentations to him. And he, in the midst of all, in the face of all this, comes out to say that she has misappropriated money. Which money?
There's a point. There's a point you made there about how the public service works. Stay with me, because your colleague and friend, Inusa Fuseni, used to be a minister too. He joins me in this. This all comes down, he said, this is the lead counsel, that it comes down to the travel policy and the way the public service governs his travel and allowances that you're entitled to. What do you say to him? That nothing was done, she's not a spending officer. And if indeed she's been done something wrong, you surcharge. You don't remove her. It's not enough grounds to remove a Chief Justice.
Evans, thank you for having me. First of all, Mr. Ayuko knows that a person who is not appointed to work in the public service cannot spend public resources. If you are invited by an office within the public service for a service, a meeting, or a conference, you are given a per diem. You are not given salary. You're not entitled to spend without something. I don't know of any policy that allows you to travel with your family on government expense. That would be impunity. Why will I travel with my family on government expense? There's a policy that allows you to travel with your family, but you must foot the bill of your family. The public service can facilitate your travel, but the bill must be borne by you, the public officer.
That is if you're traveling with your spouse.
With your spouse. And
if you're traveling alone, you're fine.
You're fine.
But if you decide to go with your spouse.
If you are traveling alone, your status is a public officer, and you are entitled to travel. But if you are traveling with any person at all within your family, you must bear and I understand. You see, I didn't want to comment on that basically. I wanted to comment on the processes.
Yeah, but now that we know the specific, that's why we'll come to the process.
Because you see, now what I have seen the learned counsel do is to re-argue his case on TV. And that will further polarize the situation. But
the matter is
this is somebody who taught at the law school for a very long time and became a director of the law school. Now, This is not consistent with the ethics of the profession.
Okay.
You can't argue your case as a lawyer.
The case is done.
No, you can't.
In this matter, it's been decided.
No, you can't.
We know the outcome.
No,
Why can't
you can't. Isn't
rather when it's subjudicated.
It violates the ethics of the profession. You can't. And Mr. Otu knows that. And in the law school and in practice in chambers, we are told never to do that. Never.
Even after the case has been decided.
Yes, to litigate your. That is why you must have opportunity within the setup, that is the committee, to forcefully make your case. Forcefully. If they decide that they do not share in your views, too bad for you. But you cannot argue your case in a court of public opinion. You cannot.
Okay, he disagrees with you. Mr. Ikotu, you disagree with that?
Yes, Mr. Evans Mensah, I told you that I'm not really enthused with this idea of a panel discussion because we had gone in to do something we call in-camera hearing. Nobody was given opportunity to come out and say anything. It is now over. And I don't know whether he has not read the case of Justice Uta Derry, where the Supreme Court ruled that you cannot gag anybody forever, and that during the pendency of the hearing, that the in-camera hearing, you are not permitted to speak. But once a determination is made, a recommendation is made, that stops the gagging order, and you have every right to speak about it. So I don't know where he's coming from with what he's saying. Uta Derry is authority for it, that you cannot stop the proceedings because somebody has gone out to say something about it in public, but it can only be terminated if no prima facie case is found, number one. And two, once the a recommendation is made, that ends the matter. Anybody is free to discuss it. So what he says is not true. That is one. Two, now under Article 127, it is provided that in the exercise of judicial power of Ghana, the judiciary, in both its judicial and administrative functions, including financial administration, is subject only to this constitution and shall not be subject to the control and direction of any person or authority. The financial regulations of the judiciary is therefore completely different from what they call the public service. And at the trial, they brought a piece of paper which said that only public officials of a certain standing are entitled to per diem. Yet, in the small print, it was clearly stated, exemption, that judicial service officers are not affected by this public service policy because they have their own policies set out by the Judicial Council. This we brought to the attention of the committee. It was tendered by Chachuchi Kata. We saw the small print which exempted them. We looked at this article which says that their financial administration is completely different. And therefore, they are bound by the policy. And yet they go about telling us that it is not sanctioned by law, it's not sanctioned by policy. It is sanctioned by the policy of the Judicial Council. And I am ready to argue every bit of this matter on this platform, and nobody can gag me telling me that you don't do that. After 44 years of practice, I don't know where anybody can tell me that after a matter is over, I cannot discuss it. Who said so? Where is it written? And I've cited the authority. Okay. I'm prepared to argue it here.
Okay. Yeah.
Whatever it is, they have said it and they've done whatever they want to do. But we are here to tell you that they have done a very poor and a shoddy work, which is only to satisfy certain individuals. And I'm sorry, my friend Hussein is a very, very good friend. I wouldn't like to go this way with him, but I'm telling him that the policy he's talking about does not affect the judiciary.
Okay.
This was made clear at the committee, and the document was standard, and we would like to show it to the public at the appropriate.
Inusa, quickly, and I'll come to Asasari, because you were on the floor when he. Well, you concede this point that there's a precedent on the matter, that this matter is something that he can talk about, but more substantively.
I don't concede the point. I have never considered the point. The point is that even within the established judicial system, when you disagree with the court, you don't go publicly to relitigate your matter.
But what do you do?
You escalate the matter.
But in this matter, there's no other avenue.
That is why it's bad.
It's finished.
That's finished.
Yeah, so...
It's too bad for him.
So
when you are litigating the matter, to what end? To what end? So, Mr. Ayuko Otu is really litigating the matter on Joy FM. To what end?
Yeah, but, okay, so there's a public interest question.
What public interest?
I mean, for all of us, this matter is the biggest...
That is why
as far as our democracy is concerned, in the Fourth Republic at least, right? The implications are there. If we now thankfully now know the reasons, we shouldn't talk about it, at least for posterity, for public education.
So when you are talking about it, you invite the committee members to come here.
Oh, of course.
Because he addressed them, they listened to him, and the other party. Because they had 4 lawyers representing the Chief Justice and 4 lawyers representing Dano. Yeah. So you will invite the other party to come and respond, rebut to what he's saying.
On a substantive matter, though, having seen the reasons, you still believe that the Chief Justice didn't have a case. They talk about, for example, the unlawful expenditure of public funds. Mr. Sanra, I need to bring you in on this. First of all, I know you had a comment on this first disagreement.
Yes, I think both my good friend Nusa and Ayuko too, have gotten it wrong. You see, Ayuko too has been invited by Media General.
By Johnny's.
Yes. So, there's nothing wrong, but, he has a point in the sense that since Ayuko too has been invited, then Joy might as well have invited the others, so because...
As the committee members?
Yes, to come in. So if you give a platform to one side, the other side, so it's a breach of natural justice. But more importantly, the point he has made that it is sort of giving Ayuko to a platform to relitigate what he has litigated already. And as a former Minister of Justice and Attorney General, he knows, or he ought to know, that there's a huge merit in the point that Inusa made. But if there's any blame at all, it should be laid at the doorstep of the entity that invited Ayuko to respond. This is, as you said, this is a matter of public interest. But I would have thought that in inviting Ayuko to come, Joy, could also have invited the other side.
It's
for
not,
a balance.
The committee members.
Exactly.
There's no way the committee members. It would be actually on that.
And Ayuko would be right in saying that in that case he would not. I thought he was going to say that if it is a panel discussion, then he will not participate. When he started, I thought that was what he was arriving at. However, this whole issue of spending whatnot, must be put in the context of the terms and conditions of, Tokonu's appointment. It's a contract. Mm-hmm. The issue is whether or not the expenditure incurred based on terms and conditions of the letter of appointment, availed that opportunity. Did her letter of appointment contain, what she did? If yes, I don't see any infraction. If no, then, it may be a contravention of the rule. So it's all a matter of contract.
Yeah, but there's
contained in terms of appointment or not.
There is a travel policy. And I want to read the relevant portion, which really should answer the question. And this is a B2 under the Judiciary Travel Policy. It says, where the Chief Justice, yes, she's entitled to travel. However, it says, B2 says, where the Chief Justice embarks on a personal or private foreign travel, he or she shall be accompanied by the security alone. This is a quote. But in this case, and she doesn't deny, she traveled with the spouse, whoever else is on the security. And the spouse also got onto the per diem provided by the state, which is the conclusion that that was an unlawful expenditure of public funds.
Meaning that, they were not contained in a contract of appointment.
That she can travel, but if you're going with your spouse,
yes. So that's
you
a
pay
violation.
For it.
So for me, if it is, a contractual issue and she sidestepped, the terms and conditions, of a contract, I mean, she's been in infraction of the law.
But don't you surcharge? Don't you surcharge her and sort of remove her? That's the point that he's making. That there's a former Auditor General there on the committee who should have known that.
It is not, for the former Chief Justice to decide, whether the Auditor General, should have surcharged. I mean, that is neither here nor there. A more fundamental point, which I find a bit erroneous in the submission of, my classmate Aiko to, is that she was not the spending officer. As head of the judiciary, she was the spending officer. And if you are traveling and the finance, unit brings you something that you are not entitled to, you cannot say, that the spending, the finance, office should have known the buck stops on the desk of the CJ. So if there have been any, financial misfeasance, she must accept the blame.
There's something very interesting here. When you read the travel policy, the custodian of the policy is the Judicial Secretary. Remember, the Judicial Secretary resigned. When the matters became public, she resigned. So why do you blame the Chief Justice? The Judicial Secretary should have known.
The judiciary, you see, the judiciary is separate and distinct from the judicial service.
Okay.
The Judicial Secretary is the administrative and technical head of the judicial service, which is the personnel and administrative wing of the judiciary. They provide technical support and administrative support. But the head, the judicial service, is part and parcel of the judiciary. Yeah. So the head of the judiciary is the Chief Justice, not the Judicial Secretary.
Okay.
Therefore, if the Judicial Secretary does something, that to all intents and purposes the Chief Justice realizes is a wrongdoing, she cannot, as it were, hide behind officialdom and say that this is coming from the Judicial Secretary and therefore, see no evil, hear no evil, feel no evil. That kind of, attitude will be a wrongful thing.
So you agree with the committee when it says this is unlawful expenditure of public funds?
I mean, if it was extraneous, outside a constitutional,
But when if it's unlawful, what law? What law does it breach? That is the key question. Because they say here, quote, unlawful expenditure. It must have breached a particular law.
The law on, spending, if you are a head of department, you have been given either some funds, and it is not the Chief Justice to administer the funds. It is for, the finance officers there or the Judicial Secretary. This whole thing, it is a disease. It's a national disease. It is not only the Chief Justice. The fact that, some of these things have not been unraveled in the past doesn't mean they are right. Our administrative officers have, over the years, treated public funds as though they are personal funds. And this is the first time that I believe we have had a committee, that has, been brutally frank, that this is wrongdoing. The error here is that Article 295 of the Constitution does not define, stated misbehavior. That is the problem. You see, and
Counsel makes that point. There's no definition.
No, and I think that the Constitution, the Committee of Experts did not anticipate that something like this will happen, and therefore did not advert their mind. If they had contemplated this arising, they would have provided for it. But the Committee of Experts did their best. It's up to the operators to decide.
Let's ask one more question on this, and then we'll deal with the procedural and big governance and democratic questions that come up. Ms. Aikotu, how do you respond to that clause in the policy? Because you cite that, which says that where the Chief Justice embarks on the personal or private foreign travel, he or she shall be accompanied by the security alone, which we know didn't happen in this case.
You see, I told you that I was not prepared for a panel discussion because those that you bring on board were not in a room with us. And therefore, there are things that they will be saying due to conjecture or things that have, been leaked into the public sphere. I don't think they are aware that these policies were amended. I made a point to you that there was a point when we had a head of the judiciary, a Chief Justice, who had no spouse. So some of these things were amended to say that he could travel with anybody of her own choice. And according to the travel policy, when whatever he gets, the other person will get half. That is a travel policy. They work. I don't know whether my friend doesn't know who a spending officer is. And he's making this kind of presentations here. The spending officer is held responsible. When the auditors come, they tell her, look, if you don't get this money refunded, we are going to hold you responsible for it. She is responsible. The Chief Justice is not. It was traveled. I traveled as minister, as High Commissioner. It is the spending officers. They work on these things and bring it to us. We don't get involved. If it is accountable interest, when you come back, you make your account by retiring whatever was given to you. In this matter, she retired 2 days after she returned to this country. And yet it was all over the place that she has not retired the interest. And I'm saying again that it is a travel policy which said that whatever is given to her, whoever she's traveling with will get half that amount. And the policy they said does not cover public officers was explained that in view of the peculiar situation of the judiciary, everything financial has got nothing to do with what they do in the public service, but what the judicial service does as an independent autonomous body. And that once they have approved that this is the way it should be done, that ends the matter. You can't import things from the public service into the judiciary. It is not everything that you can bring there.
But on the subject of the process, though, you can see that this was one that was fairly within the remit of the Constitution, and the process was followed to the letter.
What I'm saying to you is that because the Constitution makes the judiciary financially autonomous, what they do there is their business. So what we have to do or look at is the policy of the Judicial Council. What is their policy? What did they say should be done?
But beyond
what was the position as at the time that she took that travel? And when the spending officer ensured that she was paid all those things.
Beyond the specifics of the travel policy and what she spent or what didn't spend, a recommendation has been made today. Did you get an opportunity, I think I heard you say today, that your written submissions, you sent them only today on the Daniel 41?
You see why I said I would have loved one-on-one? Look, we were asked to file our written addresses by last week, Monday, or was it? Yes, and we said we needed 1 week because look, we are talking about 10,000 pages of exhibits.
Only on the Daniel 40 petition.
Only on the Daniel 40, the only one. So we asked for 1 week. That week will end today. Is it today, Monday? So
Today is 1st
this is
September.
the day that we were going to file our written submissions before the close of the day. And before we could say, Jack, this report had already been issued. They did not take any submissions into consideration. And you are saying we should not talk about it? They did not listen to us. These 10,000 pages that they are referring to, and how we saw them, these issues that we are raising, the exhibits that we wanted to make use of, which we have made use of, were never allowed to be filed because they just didn't want to know anything. They have just finished and presented their report. This enlargement of the Supreme Court, which they are using today against her, was it not the same reason they used to say that she had already asked for expansion of the judiciary? So Mahama has also decided that he will elevate 7 people to the Supreme Court. Haven't they done that? Where is the justice and fairness in what we are doing?
Please stay with me on that point. Justice and fairness, Yusuf Hussaini. How do you respond to that? This is going.
First of all, yes, I agree that probably it was a lacuna by and that trace goes back to 1969. The Article 146 has antecedents in the 1969 Constitution. That was the time that the country decided that they must remedy what Nkrumah did in the First Republic and provided for a procedure for removing a Chief Justice. And since 1969 to date, they have never made an attempt to define what stated misbehavior is. Probably they thought that was understandable. Okay, doing something which clearly is not within your mandate. Doing something that's marks of impunity, judicial impunity, which lacks accountability and so
use of office.
Use of office. Probably that's. But I think that I should think that the Constitutional Review Committee is watching this program, and so maybe they will take steps to define. So I agree. But Mr. Ayuku to say is the abuse, even if it was an abuse, ought to have been within the realm of a surcharge. Surcharge is an unlawful expenditure. You surcharge somebody for unlawful expenditure. Expenditure that is not grounded, founded in law. That is not permissible.
So you're saying that in itself is an admission that there's been misconduct?
That itself is an admission that conduct is wrong. And that's why that person has been surcharged. Okay? Now, so all that we are trying to do here is how do we deal with judicial impunity? How do we ensure? And I hear arguments by Mr. Ayuku Utu, which is frightening. For instance, it says that the judicial service should conduct their financial affairs with a regard to what happens anywhere. And that so there should be a law unto themselves. That again founds what we call judicial impunity. And that can lead to an abuse of the process. That is definitely inconsistent with good governance within any institution. Definitely. That you become a law unto yourself? No. Because basically, public resources are resources for the public. And no one has the right to spend public resources without recourse to the law. No one. Now, what has happened, like I said, derives from the 1969 Constitution. It was then that the people, the constitutional experts, thought that we should insulate the process of the removal of justices of the Superior Court of Judicature from partisan political consideration and ensure that a body like a Council of State is established, which, if you read the 1969 Constitution, will tell you what was intended for the Council of State. And as the name suggests, should be a council of states. It should be state matters that will agitate the mind of the people. So that's why a petition received by the president is not forwarded to Parliament. In the United States, a petition received for the removal of a justice of the Superior Court of Judicature is sent to Congress. In Britain, it's sent to Parliament. But in Ghana, we said insulate it because the arena of politics is in Parliament. That is why, to safeguard the integrity of the whole judicial service, you find a lot of checks and balances in Article 146 and its antecedent provisions.
So you're saying that is why when the prima facie is made by the council,
yes,
the president must suspend.
Yes.
The first real action only happens when the People's Council, as in the Council of State,
yes,
makes the prima facie.
Yes. And that is why the president has no jurisdiction, even though he's a Ghanaian, to send a petition to the Council of State for the removal. He says a citizen of Ghana. And, well, one might say that he has not exercised it because he's a citizen of Ghana. But the president's jurisdiction to act on a removal process is triggered by a petition. So he cannot, on his own, just say, well, Council of State determine whether the Chief Justice should be removed.
But
it's a check.
But I know, but that process can be engineered politically.
Well, you are saying that. That's why the process itself reposes a lot of trust in the committee. That's why the process is not designed to be, if you want, litigious. That's why they say lawyers should not be part of the committee. That's why they want the process to be understood by us. That's why they say members of the Supreme Court who sits together with the Chief Justice must be on it. So that they will understand exactly the points that are being made by Ayiko too. Is that the procedure because they are part of it? So when you look at the architecture of Article 146, its design, its conception, design, and implementation was intended to protect justices of the Superior Court and chairman of regional tribunal and insulate them against political manipulation. Look, from why do we say, why is there an Article 1466? Because the head note of the provision 146 says removal of justices of the Superior Court of Judicature. Where the application affects a justice of the Superior Court of Judicature, you send the application, the petition, to the Chief Justice. The Chief Justice for the establishment of a prima facie. But the Chief Justice, you know, Mr. Asasare has just told you about rules of natural justice. The Chief Justice cannot be a judge in her own cause, even though she's a justice of the Superior Court of Judicature. So if a petition is for her removal, you can't send the petition to her, can you? She'll be a judge in her own cause. So the drafters of the Constitution, in trying to deal with that problem, came with an institution called the Council of States. So you see, the checks and balances, clearly, I'm not saying that it's perfect, because even now we've just seen clearly that the misdemeanor has to be, misconduct has to be defined. Yeah. We just seen clearly. And if you look at the report on the constitutional experts, yeah, they say that detailed rules of practice and procedure for the removal of Chief Justice must be brought into being by the committee, court committee, so that will bring about more fairness in the way a Chief Justice is removed. So I'm not saying the process is perfect, but when you read carefully from Article 1461 to the last provision of Article 146, you'll be left in no doubt.
So your verdict is that this process has been terminated now, but if you look at it, it complies with the constitutional dictates.
No, look, the Bar Council of Britain and of England and Wales said the president must restore the Chief Justice. The Commonwealth lawyers, even our Ghana Bar Association, have said they have problems with that. But no one has said, no one, and Mr. Asasare just said this evening, no one has said that there has been a flagrant violation of the provision.
What about the rule of natural justice? He just makes the point that even their submissions were only taken today and the decision already been taken.
That's a procedure within the committee. We're talking about Article 146.
Yeah, but of course,
So,
I'm not talking about the constitution now. You're talking about the.
We don't know. That is why you ought to have invited the other party. We don't know whether they were given an opportunity to file and they failed, refused, or
on the face of what he has said.
No, I can't understand. I can't comment on it on the face because there are many things that would have happened. As a practicing lawyer, judges give judgments without listening to, without taking the submissions of lawyers.
But on this matter,
but they only do that if the lawyers fail, refuse, or neglect to comply with directives given in court for the filing of the submission of no case. I mean, for the filing of their the written submissions. And so, clearly, I don't know. I was not part. I didn't invest in the process of what was happening. I invested in the constitutional provisions, whether or not the fidelity of the provisions of the Constitution was being complied with.
Yeah, I mean, I'm so sorry. There's another key point here. There were 3 petitions. Only one was the basis for this recommendation to remove. And we are told that the 2 will be heard later. Why?
Well,
Is this legally sound?
Because, you know, they agreed, from what we are learning now, they agreed, you know, that the second and third petitions, you know, could abide the outcome of the first petition. And
Nobody
that is the
said
law.
that.
The law is the law.
Nobody said that.
So if
Nobody said that.
So if you know, but that is the screaming headline, you know, that appeared today.
Which is what?
That's
I'm
the
saying
second and
nobody said that.
third petition.
Nobody said that.
No, but
Yes,
Mr. Ikoto, what are you responding to? That the fact that they had applied for it to be heard later?
No, that we have agreed that one, the others will abide the decision.
Yes.
It is not true. They adjourn the 2 others, especially the shining one, to 15th of September. That
Oh,
is
to
all we
15th
know. So we
September.
are preparing to go back on the 15th of September to deal with the petition of signing stars. We have never agreed that one of them will abide the rest.
Okay,
We
but
never said to.
granted, granted that there was no consensus on that. Once the first petition and the petitions, you know, did not arrive, you know, contemporaneously. You know, the first one was, I think, some 2-3 days later. One had been started, you know, before the other, and therefore, once a pronouncement or a verdict, you know, had been reached on the first petition, even if the participants, you know, had not agreed, the 2, the second and the third, will become moot. What would be the point in, you
If
know,
they want to
rehashing?
say so, they should say so, but they couldn't say, and they shouldn't say that we agreed to that kind of thing. Otherwise, we will not be
Mr.
prepared.
Ikoto, and hold on. I want to read.
15th of September.
Just a second. I want to read to you part of the public statement made by the chairman when he presented the recommendation to the president today. He said the second petitioner, as well as the Chief Justice, pleaded with the committee that the second petition, which would have been next to be inquired into, be adjourned, and we acceded to their request. So did you request for this?
Yes, what is happening is this. They were to start their hearing, I think, last week. And they brought a letter saying that the lawyer was not well and their witnesses were also not well, and they will need a long period of 3 weeks before they can come. We had only requested for 1 week to say that, look, we've just finished this marathon hearing with over 10,000 pages. We are writing our address. So why don't you give us a leeway to run up the address before we start this one? This is a sequence. This is how the thing went. And they said, look, we have taken all into consideration and we have adjourned the second hearing to the 15th of September. Meanwhile, as practitioners, even if you miss a date when you are expected to file your address, just do it within a reasonable time and you'll be fine. So we went ahead and prepared, only to be told that this morning they are going to present their report.
Yeah, I'm so sorry.
And we were not told whether Chatuchikata and his people also filed any submission, any addresses. It was never served on us. We've not seen what they said. So if they use only theirs, then you can also see the justice in that one or the injustice in that one as well.
Mr. Sassari.
Yeah, so my submission is that there's nothing wrong with the committee returning a verdict or finding,
on the first
making a determination on one, and reaching a conclusion that the determination of the one, will directly affect, the second and the third petition. There will be nothing wrong in terms of procedure.
But the question is, why the rush, though? Because this is such
What
a
is
sensitive...
the rush?
Well, this is such a sensitive matter. Why don't you finish everything? Have a very holistic view of the accusations against her, and then form a holistic opinion, and then recommend.
Yeah, but this is a matter, this is a matter of public interest. The whole thing started about three months ago.
It's been 133 days precisely.
And, today we are going to ECOWAS Court, tomorrow we are going to the Bar Council and all that, So, the work must be done.
And that is the rule of law. It grinds slowly.
So
you must allow it to grind.
Whatever, one may say, in respect of what has happened, I mean, it is the law, it is the Constitution that is speaking. The Constitution is saying that there's a pathway that must be charted. And that, pathway has been charted. I keep asking, has the president acted in accordance, with the dictates of the Constitution as far as the CJ removal process is concerned? If the answer is yes, and we all know that the president has acted, to the best, of our knowledge and information, consistently with the Constitution, then he hasn't contravened any rule. But what I find a bit, disturbing now is the assertion being made by my good friend that they were not given, opportunity, even in the last moment, to have that say. That would be, a very worrying, concern. If indeed, it is true, that they were given only 1 week, and even the 1 week did not, terminate, and the report has been submitted. But, this is only coming from Mayuko. We haven't heard from the Chachu side, therefore, we cannot make
all the
committee. So we cannot, uphold, what Ayiko has said, and therefore roundly condemn the committee or the other side. So we'll leave it, all in the capable hands of, the dramatists in the drama. But having said that, the question is, was the removal in consonance with the Constitution?
You say it was.
Inusa has said, that when you look at what has happened, a certain amount of time has been spent, 10,000 days and, whatnot. But granted that they did all that, the one basic question is, were the parties given sufficient time? Because under Article 19 of the Constitution, there must be fair trial. So fair trial includes affording, the parties the opportunity to assemble the materials they will need to prepare their submission. I think that 1 week will be too short, to analyze, documentation, extending to over 10,000, and the 1 week will be too short. But I am not the committee, so I don't know what went in. We are only hearing this from Ayikutu. It is possible, as Inusa has pointed out, that a court is not bound, to wait for, the parties to, file their submissions. If time has been given and there's non-compliance, with the time, framework, the courts, can proceed, to determine the matter one way or the other. But we must all take, a cue from what has happened and make sure that the constitutional processes regarding the CJ removal, issue must be strengthened.
Yeah.
I mean, if you compare the CJ removal process and the process that can result, the impeachment of the president, the CJ removal process is a joke. It's a constitutional joke. I mean, it is as if, the framers did not advert their minds, to possibilities. He has mentioned 1969. I can tell you that in that constitution, was processed in 1968. And in the commission's proposals, Sir Edward Kufuor was very, very blunt in suggesting...
Kufuor's father.
Yes, in suggesting that the judiciary must be insulated, from the other arms of government. That's how, calm the chartered discourse. That insulating them will mean finding a separate entity, that will not be partisan. To go into, allegations of impropriety against sitting justices. So it was well-intentioned, that the operators would do just that. But if you look at, what is going on today, the problem, this nation is facing has always been the operators of the Constitution. It is not the Constitution.
You mean the politicians who...
The politicians, yes.
And because of time, isn't that the problem? That because of pronouncements people in your party have made prior to winning elections, and then now the Chief Justice is gone, this leaves, many say the precedent is dangerous, that whoever becomes the next Chief Justice is just awaiting termination through the same process if the next government comes in, as in the MPP. Very briefly, in 1 minute on that.
When you argue this way, you make a committee set up under Article 1466 malleable clear that even though the Constitution has defined and given pointers to which kind of people can be on such a committee, such people can be under the control of the president. That's what you are basically saying. And I refuse to accept that. I say that, look, and there have been many attempts under the 1992 Constitution at the removal of chief justices, but none has succeeded until this one. Because it's not an easy process. So circumscribing the grounds on which a chief justice can be removed is itself a limitation on processes for the removal of a justice of the Supreme Court. It's also designed again to protect. So if your application or petition is not within the Article 146(1) framework, you are out of the door. So yes, since 1969 to date, a lot of things have happened. People have called for the scrapping of the institution of Council of State, probably because they see that it has been corrupted by political elements within the society. Now, so we need to find, and I agree, we need to find a way to deal with that. Because you want certainty, predictability. You want to assure yourself that there will not be interference or wanton interference into the activities of the judiciary, because they are the bulwark for our protection. Yeah. So when they are at the beck and call of the political system, then we are not safe.
Okay. And very quickly to Aikoto. So this is fait accompli. I don't know, you are the lead counsel. So the Chief Justice, has she accepted her fate? Because part of this was before the ECOWAS court, but the process is now terminated. Are you still pursuing that case?
Let me make this correction. I didn't say we're giving 1 week. I said we were to have filed by 25th. I don't know whether we're giving 2 weeks or less than, but we're to have filed by 25th. On the 24th, we wrote to say that we wanted 1 week. It was when we went to the court on the 25th that we were told that Shining Stars, who were to have started opening their case, were asking for about 3 weeks adjournment. And then we were advised that we could still file it within a reasonable time. And we had only asked for 1 week, which would have ended today. So it was today that we were planning to go and file. We woke up only to be told that the report had already been presented.
Okay.
That's the point I made.
To that question, though. To that question.
So I don't want this, discussion for anybody to
you've clarified.
give ammunition to others to be saying things. I am not that gentleman. I don't do those things.
Yeah, you've clarified.
Now, as I said, you see, we all know that unfortunately, we have given a final judicial authority to an administrative body when the Constitution has said that no final judicial authority should be given to anybody. From what we are seeing, they said when they write their recommendation, the president shall act in accordance with that recommendation. So they've done it. Let us leave the ECOWAS alone. We are signatories to the protocols there, and we are expected to be guided by things we have gone to sign, pacta non servanda or something, I've forgotten. So if we have agreed that we would abide by what the international protocols will say, and now we are being told that, well, we have given them a fait accompli and there's nothing they can do, so be it. I don't know what else. I mean, if we had an opportunity, we would clearly go to court to challenge all the grounds. But where is it in that Constitution when a final authority, as it were, has been given to an administrative body? So that whatever she says is not subject to any other inquiry.
The ECOWAS, any other person. So the ECOWAS case will be withdrawn?
No. Why should we withdraw? It's pending. They should take a decision. Okay. If this thing was done to prevent them, to meet them with fait accompli, so they cannot come out with any ruling, so be it. They must take a decision. It's not for us.
Okay, so
we have plaintiffs before
them. So you're still pursuing that until the ECOWAS makes a determination? Okay. So that was...
So this affected the whole thing. Okay. And before we should come back, they have crashed, even when there are 2 other petitions waiting, that's for them, they have given their recommendation. Okay. So be it. I don't have anything to say. We'll leave it to the ECOWAS and the conscience of the world to look at what is happening.
Okay, thank you very much. And just a quick 30 seconds on that. The ECOWAS case doesn't affect what has happened, does it?
No. But I don't see, any good coming from the ECOWAS, intervention, because we are a sovereign nation, and if we are, privy or we've committed ourselves to, the ECOWAS treaties and all that, is binding, morally, it's a moral obligation, on us. We are not bound as a sovereign nation, to be guided by what an ECOWAS court will say. Okay. Their constitution is working. Their constitution has spoken. This is law in action. It is something that we must all be happy that at least our constitution in West Africa seems to be working. Let us allow the constitution to work. And if, there are any infractions, on the part of, high-ranking public officers and they come to the fore, we must deal with them.
Okay. Thank you very much. Enjoy the rest of your evening.